Well, hello everyone, and welcome to our show this evening. We are, as it says on the slide, going to give you another talk on expert evidence, and some of you watching this will know that this is about the 5th year that Tony and I have done this talk, and every year we update you with the latest cases, and there's always something exciting to say. So all of our cases today are from 2021. So I'll start with the usual reminder of why any of this matters, what are we talking about evidence for, and a reminder that we usually need expert evidence to prove a claim or to defend a claim. And in order to get that evidence before the court, we have to deal with the Evidence Act. And we'll probably all remind ourselves that the Evidence Act is a series of rules and then exceptions. And relevantly, the starting point for expert evidence is Section 76, and that starts with opinion evidence is not admissible. So it's always good to just go back and read that and remind ourselves that we are starting from it's not admissible. And in order to get it admissible, we have to make sure that it falls within the relevant exception, which in this case is Section 79. Now, Section 79 requires two things, really. Firstly, that the expert has some specialised knowledge, and secondly, that he or she gives an opinion wholly or substantially based on that knowledge. And it's our job as lawyers to make sure that we can shoehorn our expert evidence squarely into Section 79 so that it does become admissible and we're not stuck with it's not admissible. And it doesn't always work out, but it's very easy to do that, as some of our cases today will demonstrate. Now, also relevant to expert evidence is, of course, the various different codes of conduct that apply, and many of you watching will be familiar with Schedule 7 of the UCPR. Here are a couple of the salient points on this slide, and one of the points that features in a couple of my cases today is the last one there, which is that the report must set out the qualifications, facts and assumptions on which the expert rely, and importantly, the expert's reasoning. And if you don't have any reasoning, you're probably going to have a problem. Now, unusually today, I'm going to start with a criminal case. It's unusual for two reasons. One, that it's a criminal case, and the other one is because somehow the evidence did comply with Section 79. So this is a case where it all went right, and I'll tell you why that is. So this was an appeal to the Court of Criminal Appeal by an appellant who had been convicted of 5 counts of murder. The evidence against him was circumstantial, and it included a stain of DNA evidence found in his garage, which contained DNA of at least 4 of the victims. And the prosecution's case was the only way you could explain that DNA evidence in his garage was as if it had been transferred from him to the garage after the murder. And the Crown called an expert, Dr. Perlin, who opined on the application of some software that he had developed called TrueAllele, I hope I'm saying that right, which performs a probabilistic analysis of mixed DNA samples. Now, one of the grounds of the appeal was that Dr. Perlin's evidence should never have been admitted because it didn't comply with Section 79. And that is a bit unusual in a criminal case because often objections are taken on other grounds. For example, evidence is said to be prejudicial. But in this case, the only objection was the Section 79 one. It doesn't fall within Section 79. Now, there were 2 complaints about why it didn't fall within 79. Firstly, it was submitted that Dr. Perlin did not have the required degree of the specialised knowledge that we talked about, and that ground was rejected. They went through Dr. Perlin's qualifications and experience, and it was more than sufficient to establish that he did have the knowledge to opine on the effects of statistics within the samples and that his opinions were based on that knowledge. So that posed no difficulty. The second objection was a bit more of an unusual one and quite interesting for all of us because the objection was that that his opinion didn't fall within Section 79 because there was a lack of validation of the software on which his opinion was based. Now, the court dealt with that in 2 different ways. Firstly, they did look at the merits of that objection and they went through a detailed review of various scientific papers that had been presented into evidence about whether TrueLL was or wasn't an established software, all of which was very complicated and dealt with DNA in great detail. And the conclusion of that sort of merits inquiry was that there was nothing to suggest that the software was unreliable. But in any event, the court said it kind of doesn't really matter whether it is or it isn't, because Section 79 itself is not interested in the validation of a scientific theory or opinion. It does not include a test as to whether the evidence is reliable. So in order to get evidence in under Section 79, you don't have to establish that it's reliable. It just has to be an opinion by an expert based on the relevant knowledge. So that's quite interesting, where we might have experts giving sort of opinions on novel matters. It's not a question of admissibility, at least under Section 79. Now, my next case is Mattock versus the State of New South Wales, and this was a personal injury matter in the Supreme Court. And in this case, the plaintiff sought damages arising out of a head injury, which he had incurred at school playing a hybrid game, which doesn't seem to have a name, but it mixed the skills of AFL, soccer, and other games into some new game. And objection was taken to an expert report of a Mr. Armanasco. It's not entirely clear from the judgment what he was opining on, but the objection taken was that he didn't have the relevant expertise, and i.e. didn't have the relevant specialised knowledge to give evidence either about touch football, which was part of this hybrid game, or teaching. Now, there was quite a detailed discussion on his qualifications. He had been qualified, for example, as a PE teacher for 30 years. He was a highly qualified gymnastics coach, and he'd given some specific training in other particular sports, such as diving and basketball. He had training and experience in general safety and managing risks in outdoor activities and excursions. But when the court drilled down into that detail, they found, well, although he's qualified as a teacher, he didn't actually teach. And so he wasn't really qualified to give an opinion on teaching, because that was not something in which he had any experience, and he was qualified 30 years ago, but had not worked within that qualification. And also he owned up, I think, in preparing his report, that he didn't really know the rules of touch rugby and he'd have to go and look them up. So it was also found that he didn't have the relevant expertise to opine on this particular hybrid game. So the unfortunate result there was that report was rejected entirely, did not comply with 79. Now, my third case is an interesting one in the federal court, because as well as giving us some commentary on Section 79, it also gives us some good lessons on generally the form and content of expert reports and some traps that we can quite easily all fall into. Now, the facts in this case were that the Stewarts had defaulted on various banking facilities with Rabobank, and they had to sell 2 properties for prices that were beneath their expectations, as a result of which they were left with substantial debts. They sought various orders for contravention, damages, compensation, and so on, relieving them from their liability and setting aside various financial facilities. And one of the pieces of evidence that they relied on was a report by a Dr. McGovern. And his report was objected to on the basis that it didn't meet Section 79, and it was in fact rejected for a range of reasons, which are all quite important to us. Firstly, although he did have specialist knowledge and experience as an economist, the precise matters on which he was asked to opine were in relation to banking practices and procedures. So, yes, an expert, but not necessarily in these actual issues in his report. It wasn't established he had any specialised knowledge in those matters. Secondly, the questions that he was asked were objectionable. They focused on whether the parties had acted reasonably or unconscionably, which was, of course, the pleaded case. And the court said, no, you can't answer those questions. Those are normative judgments, and they are for the court. And an expert opining on those matters, we're not interested in that, thanks. So, a reminder for us that we can't ask the experts to opine on matters for the court. The third problem with his report was that assumptions that he'd asked to make were not identified. And that's pretty much a 101 for us all, to make sure that we give experts very clear assumptions and that they identify those assumptions in their report. Further, he didn't make any attempt to identify with any specificity the documents with which he had been provided. Again, that's a fairly basic matter. He had a letter of instruction, but it said something like he'd been supplied with the pleadings, the bank's discovery, which could be anything, and lay statements of witnesses. So very unspecific. Fourthly, and part of that problem, which is the lay statements of witnesses that he'd been given, they were only in outline, those statements, when he was given his letter of instruction. Now, those subsequently changed, and some of the witnesses were not called, and another one of the witnesses who had given an outline then went on to give the majority of her evidence orally. And there was no explanation as to whether that oral evidence that she gave bore any resemblance to the outline that the expert had been given and on which he relied. So it was not possible to say whether his evidence was consistent with the lay evidence on which he'd relied. Fifthly, and importantly, there was very limited disclosure in his report of his reasoning process or the basis on which he formed his opinions. And the court said it's not possible to know, because of the lack of reasoning, whether his opinions were based on his specialised knowledge. So that is the second part of Section 79. Even if he had the relevant knowledge, you can't tell from his reasoning whether the opinions he formed were based on that knowledge, which is absolutely fundamental for Section 79. Now, I think that's an important finding because it's quite different to the finding that I'm going to tell you about in the next case. But I think, with respect, that is the right finding. And that's the one we really have to worry about. If our experts' reports don't have sufficient reasoning with them, there's a good chance they will be rejected under Section 79, and you won't even get to the question of weight of those opinions. Yes? Question from Tony.
Julie, in the Rabobank case that you've just talked about, turning to a very practical matter, and you and I often in this presentation do bring it back to our own practices. My three cases all have elements of choice by counsel or choice by solicitors, or conduct of counsel and conduct of solicitors. What do you do in your personal practice when it comes to an expert who needs to rely upon lay evidence? How do you handle it?
I mean, that's a great question because it's all the time. I think every case seems to have that in it. So what I do every time is try to work out, hopefully because I've got my lay evidence, what my lay evidence establishes. And I give my expert the assumptions that my lay evidence establishes. And in drafting those assumptions, sometimes you find there's a hole in your lay evidence and you can't support a particular assumption that you hope that you want to give to your expert. So it's a very interesting process when you come to draft the assumptions, and it does make you think about what you can and can't prove. If you can't prove it, if you're giving your assumption, if giving your expert an assumption that you can't prove, that's a problem. And either you fix it up by putting on more lay evidence so you can prove it, or you start making some settlement offers, I think, because that's fundamental.
What you've touched on in the answer there is the fact that actually preparing the assumptions for the expert can be a very useful way of, a sensational way actually, of picking up holes in your own cohesion, in your own logic, before the expert actually has to opine. Have you ever, in a case, seen an expert be given actual statements of evidence, i.e. being provided with full affidavits or full witness statements?
Yeah, absolutely. And that happens a lot in big construction cases that I do, where the lay witnesses might be putting on a whole stack of documents that the expert needs to look at, whether it's drawings, whether it's quantum records, whatever it is. And the lay evidence might be, well, I incurred these costs, here are the invoices. And my expert needs to assume that those costs were incurred and then do some quantum opinion or calculation based on those evidence. So yes, it's often the case in matters that I do that the whole of the statement is given to the expert, plus an assumption that he or she can rely on whatever the witnesses say. So, is that not your experience?
No, where the factual evidence I'm a big fan of your first approach, which is drafting assumptions. Where it's possible, where the evidence is in narrow compass, I do exactly what you do. But when the factual witness is being relied upon for a number of different points, I also do it the way that you do. I do tend to ask the witnesses, possibly dangerously, to focus on, I draw their attention to the areas of the statement that correspond with the issues that I'd like them to opine on,
Yeah.
but that's about as far as I go.
Yeah.
And I'm sometimes asked, well, I'd like to criticise that witness, to which the answer is, yeah, not really the job. This is providing you with factual foundation for your report.
Yeah, I have come across that problem as well, and also the problem where the lay witness might be saying something which, in one view might not be admissible anyway, which is, here's a document, this is what it says. And then the expert comes along and says, oh, that's interesting because I've read that document and I think it says something else. And then you've got a contest between two people who are reading something, which neither of whom can probably give the answer because the judge will read the document and form their own view on what it means. So
actually just reminded me of a horror show that I had where it was abundantly obvious that parts of the lay evidence were completely inadmissible, and yet we had to make a forensic decision. And look, luckily the matter settled, so it never actually got tested. But it was a very difficult decision to make about whether to allow the expert to read and opine on the basis of paragraphs that we just knew were not going to survive the objections process, or provide it in its totality so they could get the full factual picture and not worry about its wild inadmissibility. But it's a fraud issue. It's a fraud issue,
and it's one that's often really complicated. And I think one of the purposes of giving the expert assumptions is not only because then you can work out where the holes are in your case, but obviously to protect the expert, because quite often they are opining, or their opinion might be A, but if the underlying fact changes, their opinion might be B. And so it's not the case that they've got the wrong opinion or that they can be cross-examined in a way that they should be discredited. They can say, well, yes, my opinion would be B if the facts were different, but I was told to assume the facts were this, and therefore my opinion is A. And so, they need those assumptions to go one way or the other. But when you do that, you realise how important it is that if you can't prove those, particular facts, the whole thing's going to come down like a house of cards. Right. So, indeed, it is a fraud issue. So it was a fraud issue that went down the wrong way for Dr. McGovern in this case. And the last point, the last reason why his report was rejected is also one that we all need to bear in mind. It was based on representations pleaded by the stewards, bearing in mind this was a case about we were misled, etc., without addressing the defence, in which the defendant said, well, actually, we didn't say that, or we didn't do that, or it doesn't mean this, or so on. So I'm not, obviously haven't seen his report, and I'm not sure whether he was directed to look at the pleadings and didn't, which it seems to be what the court implies, and they rejected his report because it didn't take into account the defence, or whether, in the circumstances we've just discussed, if he was told to assume that the case was right and that the defence was wrong, then there wouldn't be a problem. So that's a matter that we will have to think about by way of assumptions as well. Do you ask your expert to assume that the case that you've pleaded is the correct one, or do you ask them to also address, well, what if it's wrong and the defence is right? What's the position then? Does your opinion change, and so on? So there's a lot of commentary in this case that's really relevant to us. It comes up time and time again when settling expert reports, and it's worth a read. Now, my last case today is is in fact my favourite, because it's got a strong theme of the dog ate my homework, which I love, for reasons which will become very clear. Now, this is a case about whether Chatime had failed to make payments that it was required to make to its employees. And the Fair Work Ombudsman relied on an affidavit of a Mr. Chen, who was subject to cross-examination starting on the first day of the hearing. Now, this was, of course, last year in COVID. Everything was done by AVL, so he was being cross-examined by video link. And towards the end of the first day, he indicated that his computer was running low, and that he lost his battery charger, and suddenly his video link was cut off. Now, the cynic in me is going to call that excuse number one. On the morning of the second day, Mr. Chen, who was about to continue with his cross-examination, informed the court that he wasn't very well. He'd booked a COVID test and he wouldn't be able to continue until 2:00. So let's call that excuse number two. That afternoon, he did make himself available, but unfortunately had not obtained a battery charger and his battery remained dead. So there was some effort made to have him download the relevant video link app on his phone, which he did, and cross-examination did start again on some basis on his phone, but only went for about an hour and a half. That was the end of that day, at which point it was made very clear that his cross-examination would continue on the third day. On the morning of the third day, Mr. Chen emailed the court with a document from the Beecroft General Practice, signed by a Dr. Ronald Machado, dated that morning and stating, Mr. Chen is unwell with upper respiratory tract infection, sick. He is unable to attend online court hearing today. I'm going to call that excuse number three. Now, there was quite unsurprisingly an outcry from the defendants when the certificate was produced, and they sought to strike out the whole of Mr. Chen's affidavit and all the evidence that he had given when he had turned up for cross-examination on the basis that the certificate did not provide a reasonable excuse for him not to continue to be cross-examined. Now, the judge had to consider whether or not that certificate, that is the he's not very well certificate, was admissible under Section 79. And firstly, he said that although the certificate was sparse, and it literally had only the words that I've read to you on it, a medical practitioner, as a general matter, would have the expertise to diagnose respiratory tract infection, so therefore that was enough for the first half of Section 79. Then he went on to say that he was not prepared to give the certificate any weight. And the reasons given for why he wouldn't give the certificate any weight, it seems to me, are actually reasons why it should have been rejected under Section 79 in the first place. So what he said was, the certificate didn't say whether Mr. Chen had been to the surgery, didn't say whether Mr. Chen had attended personally on the doctor, didn't say whether the doctor had conducted any examination of Mr. Chen, and if so, what, didn't say what the basis was for the opinion that he had a respiratory tract infection, and didn't say what the basis was for the opinion that he couldn't appear online in any court hearing. Now, I mean, it seems to me that that is so obviously something that means that you can't get it under Section 79 because it doesn't show that the opinion was based on the knowledge. I mean, it doesn't do anything at all, frankly. But anyway, it was allowed in under Section 79, but then given no weight for those reasons. I think that is quite a different decision than in the Rabobank case, and I think probably with respect that that's not right, and really that certificate should have been rejected under Section 79. But anyway, the real moral of that case is, of course, that if you have a witness who wants to get out of cross-examination, you need to do a lot better than a one-line certificate produced on the morning. They've really got to have better excuse. And with that, I'll hand over to Tony.
I'm going to go out of order, folks. I'm going to start with the case of Dwyer and Volkswagen. The general theme that's emerging today is well-run cases where experts run into difficulties. Dwyer and all three of the cases that I'm dealing with are high-stakes cases where special, not in the capital S sense, but certainly more is expected of us as practitioners than in lower stakes cases. The starting point with Dwyer and Volkswagen is, again, a 10-second outline of the facts. Look, it's one of the airbag cases. Broadly, it's a class action, and the claim was bought on the basis that purchasers of Volkswagen luxury vehicles, and this was one particular ground of relief, bought cars that they would not have paid the full luxury sticker price for had they known that the car had a defective Takata airbag in it. Look, you'll all be aware from either owning a car with a Takata airbag in it, which many of us have, or alternatively, having read it in the press, that the airbags had a tendency on rare occasions, after they had been exposed to years of environmental conditions, to explode, sometimes with disastrous consequences. On the whole, as was my experience with cars with Takata airbags, the cars just went through their normal service life, and the airbag had to be replaced at a certain point as part of a recall. And that's what happened in this case. It was incontroverted that Volkswagen did replace the airbags, and the class critically did not include people whose airbags had exploded. This was in many ways a claim for economic loss. Unusually, I'm going to start with some observations about the conduct of the case. What the judge said here, Justice Stevenson said, was the case was conducted with great skill by both sides and with great economy, bearing in mind its complexities. The case only occupied 9 of the 15 days allocated for hearing. That is a tribute to those conducting the case. And look, when you read it, and it's not an easy read, it's a nicely drafted judgment, but it's factually dense. That comes through. It comes through that this was a case where every lawyer basically excelled themselves in getting to the bottom of a very difficult factual and expert scenario and dealing with some incredibly complicated economic assumptions. And yet, because of what happened in that case, you find me using it as a cautionary tale. And the cautionary tale in this case relates, of course, to the expert evidence of a Dr. Baddeley. And we start with what was poor old Dr. Baddeley asked to opine on. Her evidence was central to the question of whether it was possible to establish that the owners of these luxury vehicles had suffered an economic loss effectively the moment these vehicles made their way out of the showroom. And what she did was she was asked to design effectively an experiment. And before we move on to the separate issues with Dr. Baddeley's evidence, I think it's really important to focus on sometimes the experts have got horrendously difficult tasks. Again, particularly and another one of my cases today is economically dense constructs, particularly where they are being asked to essentially prove a semi-novel form of loss. They have to, and I'm seeing this more and more, actually create experiments, and this also happens in a number of cases involving the ACCC, which show how consumers would have behaved. So the expert is no longer confined to the good old-fashioned expert that we're familiar with, which is where you get a set of facts, you do a couple of examinations, you do a couple of building inspections, you look at the stuff, and then you opine. We're moving into a far more American model of litigation, which has been noticeable over particularly the last 10 years, where experts are now really having to get tightly involved in essentially proving up some very, and as I said before, some very complex constructs. Professor Baddeley created what were called discrete choice experiments. The result of these experiments was said to reveal that the true value of the plaintiff's vehicle when it was purchased was $25,000, i.e. sticker price $40,000 less $15,000. How could this possibly be so? It was again uncontroverted that the plaintiff had full use of their vehicle since he acquired it, that the alleged defect stayed, if it was there at all, stayed completely in the background, that it was replaced by Volkswagen, and that therefore the owner was essentially left in the position that he would have been in but for the original installation of a possibly faulty airbag. In paragraph 211, we hit the crux. The plaintiff contends that he overpaid for his new vehicle because its value was reduced below its purchase price by reason of the potential for the airbags to misdeploy. That proposition depends on the results of the discrete choice experiments. Now, rule number one, if your expert has to carry out an experiment, if your expert's report lies on a construct, then you, in my view, as counsel or as instructing solicitor or as both, need to pay very careful attention to whether it survives the real world test or, frankly, even the common sense test. Look, I respect the other school of thought, which is that the expert should be left to their own devices and that it's up to them to come up with their own constructs, and in this case, to engage a professional survey company to conduct an online survey based around some very unusual assumptions. So again, this is not a Mount Sinai perspective. The reality is there are two schools of thought. Mine, which is, look, at the end of the day, we've got an overarching obligation to make sure that the litigation is conducted in a certain way. And then there is an alternative view of that overarching obligation. Both are actually correct. It just depends on, in my view, it depends on the circumstances of the case. I prefer to allow experts to go untended wherever possible. But when I see things starting to head in unusual directions, then at that point, I will tend to intervene. So what was this online survey? Basically, a group of respondents was asked to answer 10 multiple choice questions online. And the gravamen of those questions were, and I'm just going to summarize this without the case in front of me, if you knew that the vehicle had a faulty airbag in it, would you pay the same price or would you pay less? Now, that is a dramatic oversimplification of what this survey did, but nonetheless, that was where it ended up. The plaintiff in its opening argued that Professor Baddeley's discrete choice experiments were an appropriate basis for quantification of the alleged model. And her model, quote unquote, applied accepted economic methodology and produced plausible results. Pausing for a second. No one in this case said that Professor Baddeley was unqualified. No one in this case said that Professor Baddeley was, again, other than a fine professional who grappled with a very difficult issue. Professor Baddeley found herself at the end of some fairly difficult criticisms, but it's important that in this case, it's a starting and ending proposition that Professor Baddeley's skills and experience and knowledge in her field was not impugned. Really, the end of the case was that Professor Baddeley was a square peg in a round hole, and Professor Baddeley was, there were some suggestions that Professor Baddeley was perhaps temperamentally unsuited to being an expert witness. This will carry forward into the Fonterra case, where we see an alternate version of that factual scenario. So the judge made a finding, Professor Baddeley, or at least a comment, that Professor Baddeley is a highly qualified and academically, deeply experienced economist and econometrician, but she did not present well as a witness. Again, I have the benefit of having it in front of me and you don't. But when you have it in front of you, Professor Baddeley is a highly qualified and, academically, deeply experienced economist and econometrician. You as the reader are more than entitled to read what is clearly being implied into that statement. And when you read the next paragraph, but she did not present it well as a witness, really paragraph 225 is more or less unnecessary because by the time you finish with 224, you've gone, Now, here, this particular judge made a, again, it's an inferential comment about academically. We're going to see in Fonterra, which I'm going to come to later on, that the entire difference in the case between the two experts related to academic and their academic qualifications, their academic expertise, and the extent to which they lectured in the specific field. So it isn't merely because an expert is highly academic does not mean that they should be ruled out of consideration. Quite literally, if you read Fonterra and you read Dwyer side by side, you'd think to yourself, well, on the one hand, the highly academic expert brought the case home, and on the other hand, the highly academic expert got so caught up in constructs, academic style constructs, that on one view, her evidence sank the case. The sinking of the case is fairly obvious by 226, where the judge writes this: in closing submissions, the plaintiff accepted that Professor Baddeley presented as a somewhat naive and experienced court expert. And then Justice Stevenson goes just that one step further and says this. This is already after the plaintiff has abandoned their expert. That is true, but I would go further. Professor Baddeley, consciously or unconsciously, pause, smile at camera, has become too closely aligned with the interests of the plaintiff and the group members that she represents, and has allowed herself to become something of an advocate from them. So, I mean, God knows we love a judgment that heads into the subconscious mind, but the punchline is that there is a very distinct finding here that Professor Baddeley, again, who the judge says is esteemed and highly qualified, crossed a line. But again, it's really not the crossing of the line that I'm most interested in. The most interesting part of this case for me, again, this is just in many ways just yet another case of, again, an expert who falls over in a really well-run case. But frankly, it's the concept of the experiment that really fascinates me. I'll come back to the criticisms of the expert in a second and just highlight for you some errors that if you can ever stop the expert from making, you really should. Let's rewind. Expert engages a survey company. Survey company puts together a survey. Survey goes out to participants online. Something I haven't told you previously, the participants were rewarded. There is no suggestion that the reward was contingent on answers, but it was a survey for reward. There is evidence that the survey is conducted very swiftly, i.e. the average participant was clicking on the answers without giving them a great deal of thought, where thought is expressed as a time component. And again, the premise is, would you have bought this car if you had known, as a value proposition. Firstly, would you have bought this car if you'd known it had a defective airbag? And then, what would you have paid for that car, knowing it had a defective airbag? So it's the second element that's far more important. It's the what would you have paid for that car, knowing that it had a defective airbag? Because again, you've got to tie it back to the plaintiff's loss. The plaintiff is saying that there is an economic loss caused by the fact that these cars should never have had a sticker price of 40. They really should have had a sticker price of 25. Therefore, the economic loss is 15. This is where I think the judge gets it absolutely, completely right. 238. A fundamental difficulty with the discrete choice experiments is they were based on a highly unrealistic premise, namely that a rational person would buy, at a discount, a car known to have a defective airbag. I think VW was correct to assume that the scenario the participants were thus asked to assume was so artificial and so implausible and removed from reality that any views thereby expressed about Volkswagen vehicles could not be treated as an insight into value. The judge also highlights three other problems with these experiments. The first one is that what this does is it assesses, at best, the amount that a purchaser is willing to pay
for a vehicle with a hypothetical construct of a defective airbag. The judge points this out, that it's no doubt true that in the real world there would be not a market for vehicles known to have a defective airbag, not least because no rational and responsible vehicle manufacturer would offer such vehicles for sale. Now, this was a conclusion that was open to the following people to reach before the survey even went out to the participants. Number one, poor old Professor Badley. Number two, every other person who was involved in that case. Now, and again, there are two schools of thought here. I only have one. I have one, and I'm not going out of my way to be nice to the other theory when I say it's entirely valid. It actually is. Personally, I dig down fairly deeply into the instructions that go to my expert in larger cases, and I do make inquiries about what the expert's methodology is going to be. Litigation is getting more and more complex. Experts are becoming, and again, this is, I'm afraid, sounding a little bit like a dirge, experts are becoming more and more specialised. And the simple old days of review, opine, and then go home are well and truly over. So look, I dig in deep. And what it strikes me is that in this case, which was a very well-run case, that at some point in time, everyone got so close to it, as you do in cases, they got so close to it that it wasn't seen that that this entire methodology was open to such a slamming criticism. It's no doubt that in the real world, there would not be a market for vehicles known to have a defective airbag, not least because no rational and responsible vehicle manufacturer would offer such vehicles for sale. And God knows I've gotten too close to cases. You spend a year or two in them, and at a certain point in time, you learn that, frankly, it's all in. You're really only seeing the fine. You're only really seeing the fine details. A second difficulty with the experiment was the participants were asked to assume a false level of risk. The opening statement to the participants clearly conveyed that the risk of airbag malfunction existed from the date of manufacture. It's common ground that such risk as existed did not arise at the date of manufacture, but only after many years and exposure to temperature fluctuations and moisture. Now, that one there is a factual instruction, and it is a semi-fatal factual instruction. If the participants in this survey were asked to assume that there was a risk of malfunction from the date of manufacture, and it is simply not the case, then again, it is possible that if the expert had turned her mind more clearly, or if others in the case had turned their mind perhaps more forensically, and again, this is all ex post facto rationalisation, it is possible that it could have been caught before everyone finds themselves in the horror show scenario of having to walk away from their own witness, their own expert. I've done it once, I know what it feels like, and again, so I can completely sympathise with those who are involved in the case. And again, I think in the case where I had to walk away from my own expert, I had an uneasy feeling in it for quite some time, but there was always something else to do. There was always another crisis. There was always something else to look at. And the reality was that it was actually during the course of the proceedings that the full, shall we say, the reason for my feeling of unease became fully apparent. Interesting one. A real question arose as to what level of consideration participants gave to the survey. Participants had an incentive through a points or reward system to complete the survey as quickly as possible. Metadata from the survey, again, if you're going to put on a really bad survey, make sure that there's great metadata to show exactly how bad it is. Metadata from the survey showed that 5 out of 6 participants read the complex opening statement at a rate that exceeded the average adult reading speed. The metadata also showed that half the participants answered the questions at a median speed of 10 seconds or less, and that a high proportion of respondents gave inconsistent answers. It will come as no shock that at paragraph 252, the judge says the discrete choice experiments were deeply flawed. In my opinion, they were of no value to the task at hand. Let's now move to Professor Badley, because again, the reason for taking you to these cases and doing a deep dive on them, which is, again, the reason for doing the deep dive is what are the broader lessons that we can learn? What are these cases useful warnings of? There is always a case that we throw at you, which is the what's coming our way from overseas. But this case falls straightly in, fair and square into these are some lessons that we can all remember. We have the initial criticisms of poor old Professor Badley. Her model was again, well, it didn't survive analysis, but there is a real problem with the way in which she behaved, and again, I have great sympathy for it. In July 2019, Professor Badley presented a draft document for discussion with the plaintiff solicitors entitled Discrete Choice Methodology. That document contained a note from Professor Badley to the plaintiff solicitors, and this is what the note said. We will need some guidance from the legal team on how narrow or broad this range ought to be, based on their expectations around how much the average consumer needs to be compensated. This is the way the judge treated that. In closing submissions, the plaintiff pointed out that no criticism was made of the discounts ultimately adopted by Badley, but that's not the point. As Volkswagen for the defendant submitted, Professor Badley's note represented a request from her for information to design an experiment that best fitted the answers the plaintiff's solicitor hoped to derive. I can envisage no good explanation for an exchange of this kind between a supposedly independent expert and the solicitors for the plaintiff. None was given. Indeed, as Professor Badley said when this was pointed out to her, I agree that this was not an appropriate thing for me to say. Now, earlier today, I was in a conference with experts who had done, at my and my solicitor's request, a review of an organisation structure. In oral conversations with my instructors, the experts, who are management consultants, highly skilled management consultants from the very, very top end of town, had indicated that they had a series of findings that they would make in their report about the conduct of relevant people, and that they had many concerns about the conduct of relevant people. Using the joys of screen sharing, first thing, using the joys of screen sharing this afternoon, if you don't know your experts, don't get them to send you a draft. I frankly had this CLE on my mind, and I was thinking to myself, God, maybe it would be easier if they just press send, but know well enough not to do that, and more bluntly, so did my solicitors. So there was no question that I'd be saying just press send. The draft pops up on screen, and there is criticism of the systems that are in place. There is criticisms of software. There is criticisms of hardware. There was a statement that the relevant, that the people in the organisation's titles corresponded to the job descriptions that you would expect to see in the organisation. And then I then said, right, next slide, because I knew the day was running short, and then there was no next slide. The next slide did not contain the punchline, which was, what was the conduct of the people? Why, in other words, and I was eagerly anticipating this report because I knew and I know that when properly drafted, if it actually says what my experts have told my solicitors it will say, it will go straight down to prove one of the grounds that I need proven. I had one question for them, which was, well, you're missing pages here. And then I got this response from them. Oh, look, we really don't like to comment on people. So what I was in a position to say to them, without any frustration, was that perhaps they could kindly actually reread their letter of instructions and answer the question. But what I had there was, and then they followed it up by saying, why don't you, and again, this is all very coincidental, and it occurred to me literally I was reading that case right then. They actually said to me, well, why don't you just tell us what you'd like us to say? And that was actually quote unquote. And this happened today. So any suggestion that this kind of question from an expert and again, really high-end, $1,000 an hour, expensive as hell experts who really should know the hell better, doesn't happen or only happens in the remote confines of a case like this. Again, this was my day. Now, what did my solicitors save me from? My solicitors saved me from the following things. They did not allow a note to go through. They did not allow a draft to be sent. They arranged for screen share, and they made sure, as good solicitors do, that multiple drafts were not floating around. They adhere to the school, and again, I also adhere to this school, that frankly, we live in a world of backups, but it is perfectly acceptable to have one copy of your report, save it on your desktop, and when you make changes to it, keep on overwriting it. Now, yes, a copy or two will get caught up in the cloud backup. We all know we don't live in the world we did 10 years ago, but at least what you'll do is you will not have a vast array of drafts. Julie, do you call for drafts?
I find more often that I have to get drafts and muck them up. So I'm not in a position where I can just look at it on the screen. I get a draft that I have to do something with. And my approach has always been, following the McDougall decision that says it's up to lawyers to make sure that expert reports are intelligible.
Yeah.
I was taking the view that it's my job to amend that thing,
Yeah.
not to touch the opinion, but to make sure that you can actually follow what they're saying. Because half the time, experts, bless them, can't draft a topic, and what they produce is utter nonsense. And you've got to, try and decipher what on earth they mean before you can work out if they're not any good or is helpful in any way. And I have no problem with that, in the sense that I never try to change anyone's opinion. And the comments that I make always come with a big fat disclaimer from me that says, these comments are intended to clarify your report. They're not intended to change your opinion. And if you think that they change your opinion, you should reject them. So that I'm always happy that if those drafts did ever appear, that the changes would be clear and the reasoning would be clear and there wouldn't be any criticism. But on this topic of experts saying, what do you want us to do? I find that is more and more of a problem in recent times. And my own recent experience is when I have prodded an expert to say, why is this your opinion in answer to this question? And what they've told me orally, thankfully not in their report, was, well, I was looking for an answer to help the client.
Yeah.
And, there's such a big red flag there, because even if you then explain to them for the millionth time that their job is to be independent and to give an answer based on experience, not one that is just shoehorned to assist the client, if that's the way they're thinking, it's really hard to shake that. And probably that expert's going to be an absolute disaster by the time they get in the witness box. And it's a real problem.
And I think what you've hit there is also that is a sentiment that's very clearly applicable to the inexperienced experts. Absolutely. The more experienced the expert, the less likely at some point in time, a Professor Baddeley of this world will have run into us early in their career, and one or the other of us will have said to her, that's not the question. No. You cannot ask that question. And this all seems like a bit of a construct. And as you say, we will often catch it early on. But certainly, you're absolutely right. It is a complete red flag when an expert says, what do you need? And of course, hearing what Julie's just said, I've just realised that my day's now even worse than I thought it was. Now, the second case, which is Fonterra Brands. Look, this is a very quick one. All the action takes place in 2 paragraphs. It is a gloriously complicated case. This is the commercial jurisdiction at its very best. It's where you're looking at brand damage, the concept of was the handling of a brand detrimental to the trademark? So we are dealing with a highly specialist field here. There were two experts. There was a Professor Sullivan and there was a Dr. Honeywell. We are dealing here with two really well, again, very well run cases where one party got Professor Sullivan, a professor of marketing at the University of Melbourne. He was the only expert, says the judge, with academic qualifications in marketing. He has over 20 years' experience as an academic in the field of marketing. His research work has been published in the Journal of Marketing, the Journal of Academy Marketing, the International Journal of Research in Marketing, and so forth. You can guess how the rest of the paragraph runs. He's worked with a consultant, with branch managers and company personnel on how to develop and implement effective marketing strategies in the fast-moving consumer goods industry. The companies he's worked with include global consumer product companies such as Johnson & Johnson, Moët Hennessy, Louis Vuitton, Nestle, and Mars. Unsurprisingly, Professor O'Sullivan was a very impressive witness. In the other corner, unfortunately, you have poor old Dr. Honeywell, who was, again, this is not Dr. Honeywell's fault. He was brought in, and by all accounts, he did a good job, but he didn't have academic qualifications in marketing. He'd never been published in a peer-reviewed marketing journal or publication. He's an adjunct professor at the School of Economics at the University of Tas. He has not conducted any research or teaching that is relevant to opinions expressed in this case. He's had experience conducting consumer research and working with businesses in relation to marketing issues. However, here's the kicker, he has never provided such services to any supplier of fast-moving consumer goods to supermarkets. What's the lesson here? At some point in time, you know you're up against Professor Sullivan. The moment you know you're up against Professor O'Sullivan at that point, and there are a million Professor O'Sullivans are out there, and we've been up against Professor O'Sullivans many, many times, you've got to look very carefully at whether your Dr. Honeywell is relevant to a different part of the case, but can actually be fairly asked to opine on areas that fall fairly and squarely and slap bang within the expertise of a Professor O'Sullivan. And remember, Singapore is just a 5-hour plane ride away, and it is an active commercial jurisdiction, and there are a whole lot of experts there who, in exchange for vast amounts of money, will happily come to Australia and opine. Hong Kong is also very useful as well. It ain't just about Australia these days. I use Singapore constantly. I keep telling my solicitors I need to go there. I never ever get sent there, but one day it'll happen. The final case. Look, it's a... It lies at the heart of what it is to be an expert. This is a case where a gentleman went on a holiday. He ate a burger at the airport before he left on his holiday to Turkey. And from the moment after he ate his burger at the airport, he was in the hands of a holiday package. So he flew on a package airline to a package hotel, ate package meals, and then flew home. He became desperately ill. Now, the question was, is it likely, balance of probs, that he contracted his illness, gastro, of a fairly severe variety, while he was A, at the airport, B, before the airport, or C, on the package? Because, of course, he was suing the package provider. The expert report was 4 paragraphs long. It was by a highly qualified expert. No one had any problems with the expert. The expert says things like, the possibility cannot be ruled out that Peter Griffiths had 2 infections, one starting on the 4th and the second starting on the 11th. On the balance of probabilities, the absence of vomiting as a symptom makes a viral cause much less likely than a bacterial one. On the balance of probabilities, Peter Griffiths acquired his gastric illnesses following the consumption of contaminated food or fluids from the hotel. This is not a strong report. It's an expert doing the best they can with a limited set of instructions. What happened next? The other side didn't put in any expert evidence. They were meant to, but they didn't get around to it. The experts, Professor Pennington evidence was then allowed in. What did the judge, and he wasn't called. Professor Pennington was not called. And the first criticism of Pennington's evidence came in final submissions. So, report is tendered, not called, no cross-examination, entirely untested. Plaintiff, well, it's not tested. All you have to do is check whether it complies with the equivalent of the Uniform Rules for Civil Procedure, and if it does, then it's uncontroverted evidence, and the judge's role is not to test it. Judge, in my view, bravely and entirely correctly, judge says, well, look, it's just not that simple. She saw deficiencies which, frankly, were there on the surface in the judge's report. And she effectively said that the expert's evidence did not provide a conclusion that could be relied upon as to the actual cause of, in any determinative way, the actual cause of gastro. She went on to decide that he hadn't proved his case, and therefore she dismissed the claim. She pointed out that the burden of proof was on Mr. Griffiths, and that it was, quote, open to a defendant to sit back and do nothing save make submissions, and if the evidence is not sufficient to satisfy a court on the balance of probabilities, a claim will not succeed. You know what comes next. There are multiple appeals. It makes it basically all the way to the top. And the top says, yeah, the judge got it right. It is up to the judge. The judge is not a rubber stamp. In a case where it is a single report put forward by a party, then whether it is controverted or otherwise, the judge is still entitled to form a view as part of effectively as part of a weighing up of all of the evidence in the case, whether the evidence establishes the case on the balance of probabilities. As part of the reasoning of the appellate courts, and this is the final part of this is the final part of today, the court painted, however, an interesting exception to that, which is in the case of a joint expert report. Where there is a joint expert report, it would seem the court would take a different path, and that is that if you have a joint report and you do not object to it, then you actually will find yourself in the position where the judge has no work to do. So coming our way in Australia, which we'll keep a track on, is number one, the treatment of joint reports. My advice would be, if you don't like it, always take a point. And then secondly, that even though it is possible for you as part of submissions on expert evidence to criticise an expert, even if they're not called, look, my inclination would be nonetheless, I would be putting the plaintiff under a great deal of pressure to call the expert, and I'd probably be making sure a letter was written to their solicitors warning about what I'd do if they didn't. I think we're slightly over time. Thank you all very much.